Not needed. You're not needed.
Good morning. We welcome everyone to our December argument session held via WebEx. We've done this now a number of times. It seems to work fairly well, and we find it preferable to doing a telephone conference that the U.S. Supreme Court does, because we can see the lawyers can see all of us. If there are technical problems arise, notwithstanding everyone's best efforts, we can usually work around those and take care of that and keep moving forward. We have a fairly long list today, so we do want to move the list along. And as I always remind the council, you can take comfort in the fact that we have your briefs in front of us. So don't worry if a point or two which you would have made, because they're amply covered in the briefs. With that, call the first case.
The first case is Ryan F. Mortimer versus McCool Properties and 340 Associates. Representing Mr. Mortimer is Mr. Joel W. Goldberg. Representing McCool Properties is Mr. Robert A. Burke.
Good morning, Mr. Goldberg. Appeal was allowed in this civil case on a limited basis to consider the circumstances under which one corporation may be held liable on a judgment against another, which is generally referred to as piercing the corporate veil. Specifically, the court is asked to consider adopting an enterprise or single entity theory of liability. That you can introduce yourself and begin your argument.
Thank you, Your Honor. On behalf of the appellant, Ms. Ryan Fell, I'm Joel Goldberg, and this Supreme Court granted our appeal to determine whether Pennsylvania should formally recognize the enterprise or single entity theory, which we suggest is necessary to fill a void exploited by these appellees in the present appeal of these consolidated equitable veil-piercing actions. Our Commonwealth has long recognized that a corporation, or in this instance, a limited liability company, is an entity separate and distinct from the individuals comprising it. Thus, the shareholders or members may not be held liable for the debts of their company. However, this privilege of limited liability is not absolute. Our courts have disregarded this legal fiction. If a corporation or a limited liability company is a sham, constituting a facade for the operations of the dominant shareholder, whenever justice or public policy require. Now, our courts have historically applied traditional veil-piercing principles to hold shareholders responsible for the debts of their companies. That's vertical or traditional alter ego piercing. And our Commonwealth also recognizes reverse piercing, where a company will be held liable for a shareholder's individual debt. Also vertical piercing. By adopting the enterprise entity or single entity theory, these same traditional underlying veil-piercing principles may be applied, but simply laterally between two sister companies. It's a common sense progression that will enhance our jurisprudence in order to prevent injustice where there are these sister companies with overlapping ownership that operate as a single corporate combine. Doing so will help protect innocent members of the public from the foreseeable harm wielded upon them by sham limited liability companies created solely to shield its owners from their own willful negligence in disregarding of the rights of the members of the public. After all, if these business owners fail to honor the separateness of their own entities, why too should our courts? To provide brief context to the facts of this appeal, my client, Ms. Ryan Fell, is a judgment creditor after an overserved patron crashed into her when she was just 22 years old. That patron had been overserved alcohol at The Famous. The Famous is housed in the first floor of a
Mrs. Goldberg, Justice there. Very respectfully, I can speak for all of us. We know we're a hot court. Can I ask you a question?
Of course.
We live in a little bit of an ivory tower. We no longer get to practice law. We don't get to see, even with the trial courts, see. In terms
Justice Baer, I'm so sorry to interrupt you, but I can't hear you. I don't know if the others can.
Thank you, Justice Scott. Can you hear
You're
me?
welcome. Yes.
Okay, I will keep my voice up, notwithstanding the iPad. Thank you. Let me begin again. We live in a little bit of an ivory tower. We do not see what the real world sees, especially even the trial courts. My concern is that I don't want to upset a way that the state does business because of some philosophical concern. Just assuming for a second that everybody in the liquor business puts their liquor license in Corporation A and puts their real property or their lease of real property into Corporation B, and all of a sudden we say you can't do that. Are we getting in the way of the legislature? Are we overturning something that will have catastrophic effects, as you said, on limited liability, which is well recognized in the law?
Your Honor, no. To answer your question quite simply, we are not going to, should this court adopt the single entity theory, it is not going to interrupt any business or bar business in the state of Pennsylvania. Because you are correct. Usually a bar operates in one entity while the property is owned by the other. This has been approved by prior courts that have analyzed this ownership structure. The difference here is that the entity that was formed to own and operate the bar did not. And whereas in the other cases, historically, the bar operating company will enter into a lease with the property owning company, which serves to set forth the relationship between these two entities. However, here, these appellees did not do that. Instead, they had a manager, largely unqualified manager, enter into a lease with the property company. So the difference, one, if you're going to own a bar and operate it, there's a potential profit for the business. Here, this bar company had no ability to earn a profit based on the management agreement because the owners of both entities viewed this as a real estate transaction. That's what they testified to. So what they did was pilfer as much money out of the building as possible without regard to how responsible their own manager was for the service of alcohol.
You say their manager. And I'm trying to understand. I'm not following entirely. A little complicated. You say their manager. As I understood the record, and I say we all get ready, the famous Mexican restaurant was a discrete entity. It was not bogus. You're not seeking to pierce the corporate veil to get to the restaurant. I presume you already got the restaurant's insurance proceeds. But the restaurant is Corporation C, if you will. Corporation A being 340, which owns a liquor license. Corporation B being McCool Properties. So, and you're trying to laterally get McCool Properties, the real property venture, to pay the debts of 340, the liquor license owner.
Well,
So, are you saying that the restaurant's part of this collusive entity?
the restaurant was operated by someone wholly unqualified without any experience, and there was no insurance. The entity that operated the entity that 340 Associates told the LCB, Liquor Control Board, that they operate the bar. 340 Associates told the Pennsylvania Department of Revenue they are the bar operators. That is why every month they remitted sales tax payments on the food that was sold to the Pennsylvania Department of Revenue. They represented to the state that they operated the bar. However, they did no such thing. They intentionally did not operate the bar, did not supervise their manager, this landscaper. They did not make sure that the risks of running a bar were attended to.
May I interrupt you for a second just to make sure that I'm following along, and hopefully my colleagues also. Therefore, in an alter ego, without getting into single enterprise, you can pierce the corporate veil to get from the restaurant to 340 or 340 to the restaurant, because what you're describing is a sham restaurant actually being run by 340. Have you done that? You don't need a change in Pennsylvania law for that, if I'm understanding this.
The famous Mexican restaurant was a company owned by different parties. It was the manager's company, and there were no assets. There was no money in that account. I mean, there was no way to collect any amount of money from the famous LLC on the underlying dram shop case. There was no insurance maintained by the bar manager, even though the management agreement arguably required this landscaper manager to do that. And it was set up like this because the individual appellees had a building with a bar in it, and they represented to the LCB that they were going to operate the bar, but they did no such thing, and they never intended to do that.
I guess I understand. So your bottom line is that you've gotten what you can, which is nothing from the restaurant. You've gotten what you can from 340 after a fraudulent conveyance action, which is the value of the liquor license, and your client is largely still has a multi-million-dollar verdict that's unsatisfied. Now you're looking at the owner of the real property, right?
That's correct, Your Honor.
Could I follow up on 340, please? Justice Barrett was asking about 340. Let me follow up on that briefly. Didn't the trial court find that Ray had no interest and no role in 340 Associates? Given that finding, how do you establish the identity of ownership required under the minors test? Doesn't that, how can we go any further here?
Well, I think that, Justice, the identity of ownership here does not necessarily have to be identical based on the trial court's erroneous finding, which, contradicts all of the every financial record from up until 2013 when this veil piercing action was brought, and the prior trial court judge entered an order denying the preliminary objections of the appellees, saying that if there's an identity of ownership, that's a factor under minors. But the appellees then went and amended tax returns that had the father as a 1/3 owner. Now, it is an erroneous finding of fact based on, or kind of conclusions of law that are erroneous. As an LLC is a pass-through entity, the only way that both 340 Associates and McCool Properties could properly be taxed to the partners is if they have an equal number of owners of both companies, since they're both pass-through entities. And, you know, the father was admittedly a one-third owner of the property entity, in addition to the bookkeeper for 340 Associates that was unpaid. The father, while he was alive, was the one remitting the amount of monthly sales tax to the Pennsylvania Department of State. So I think if you were to look at the totality of the circumstances here, that's a finding that is based on a mistaken premise of law by the trial court, and one that just shocks the reasoning of.
But you see the problem, right? I mean, you really need to get us to find that to be some sort of legal conclusion, because that's a barrier for you, isn't it? I mean, if Ray had no role, if he had no role in 340 Associates, how under any test could we hold McCool Properties to account?
Well, Justice, I think that is an erroneous conclusion of law, because the trial judge mistakenly found that Ray was not an owner, despite the mountain of evidence saying that he was. And if you were to look at how these two companies interacted with each other, I mean, 340 Associates did no business. They had no employees. They didn't do anything other than serve as this liability shield for the inevitable unfortunate events that would happen at the bar.
Mr. Goldberg, that's why we have intermediate courts. We don't review the decision of the trial court. We're reviewing one thing, and that's the determination of the period. If there's an error, the trial court been corrected, the superior court, what happened?
Well, the superior court, again, these are factors that have to be viewed in the lens of injustice. I mean, it is an equitable matter before the trial court, and when the lower courts do not recognize the injustice. In fact, what the superior court found was that all of these bad events that were ongoing at the bar did not matter. They didn't factor into any determination as to whether 340 Associates was adequately capitalized, and that is a mistake of law. But that is why we need to adopt this single entity theory, because if we were to look at traditional veil-piercing factors to get from 340 Associates to the individual owners, there is not much commingling of funds between the individuals. Instead, what they did was siphon money to the property entity, which the father, Ray, was admittedly an owner of and profited from.
Counsel, it's Justice Donahue. Is my understanding correct that 340 Associates essentially had no income and paid no expenses?
They had no ability to earn any income.
Well, but it's not a question of ability. I mean, if they were paid a licensing fee or something of that nature, that they had that ability, they held the license, they could have charged the fee for it. They did not do that.
That's correct. They could have, but chose not to.
But they didn't. I mean, I'm just trying to deal with this record, and I'm trying to get to this issue of identity of ownership. I mean, is it necessary that it's precise identity, or is substantial identity sufficient? We're in this case, and I'm trying to understand this. In this case, 340 Associates, essentially the owners, two owners, and let's just assume for the sake of discussion that there were two owners of 340 Associates and three owners of the other entity. The two owners generated no income, generated no operating losses that they could carry forward or use in a tax sense or anything of that nature. So the shareholder, or the limited liability members of that corporation actually had no substantial financial interest in terms of that company. So everything that was being, every dollar of income that was being generated by leasing the space to the bar was going directly to McCool Properties. Is that correct?
That is correct. Absolutely. And I would urge the court to look at the actual relationship between the entities, because the father was a substantial owner. The father was an equitable owner of 340 Associates, because their father, up until tax returns were amended well past the operation of the bar, the father was, because it's passed through entity, there were deductions on the individual tax returns that were offset by gains to McCool Properties.
Is there something wrong with the pass-through? And I'm asking this as a matter of law. Is it inappropriate with pass-through entities to have different owners or members of the business entity on one side of the pass-through versus the other? Or does there have to be a symmetry?
No, in this particular set of facts, there has to be symmetry, because if there's two members who are taking deductions for the amount of the amortization of the liquor license, in this particular situation, it does not work. There is nothing inherently wrong with having pass-through entities where taxes are paid at the personal level. That's entirely appropriate.
Mr. Goldberg, I'm sorry, are you done, Justice Donahue?
I am.
Mr. Goldberg, we're going to conclude this argument, but I had a question. Unless this bar was a charity, which it wasn't, who got the money?
McCool.
And that's who you want to go after, right?
Correct.
I got it.
The property owner. I mean, they view this as one building.
Well, I understand all that, but the restaurant wasn't a charity, so the money went somewhere. And whoever has the money is who you want to go after, correct?
That's correct, Your Honor. It's the property owner, the only entity that received any rents from any business going on there.
Could I follow up briefly, Chief?
And I also, Chief. Go ahead, Justice.
Sorry, Justice Donahue had asked a question, counsel, I wanted to pursue further briefly. Is it your position that the minors test would allow this sort of piercing, not only for identity of owners, but for just common owners? The existence of some common ownership? I mean, does the test go that far? Is that what you want us to hold? And if it does, is there some sort of finding of wrongful conduct required? And here we didn't have some finding in the trial court of wrongful conduct. So I'm not sure what test you want us to articulate here, and even what the authority for it would be.
Well, thank you, Your Honor. The test we are advocating for is a higher standard than minors for a court to use to pierce. It is one that requires injustice. And the lower courts need to have a proper understanding of what that injustice is. Because if bar owners all over the Commonwealth copy this ownership scheme, there is likely to be a lot more danger to the communities around the bars. There's going to be more uncompensated victims. And it really is an injustice to all of the responsible restaurant owners, the responsible business owners that aren't just hiding behind shelves when they know that they're conducting business in a peculiar, highly risky industry.
Mr. Goldberg, Justice Beer has a question, and then we're going to conclude your argument.
Chief Justice, thank you. Actually, I had the same question as Justice Webb. However, you didn't answer it to my satisfaction. We have a very narrow issue here. Should we adopt the single enterprise theory? We can, and I'm going to talk to the other side about this, but we can remand for application of that. However, the test cannot be, was there justice? That's a disaster for the trial court, intermediate appellate court. So what Justice Wecht asked you is, in terms of, in my parlance as I saw it, is, do you, after living with this, want to advocate the minors test? Do you advocate something more? If we're going to adopt, if you're going to prevail here, what's the test, in your view, that we should specifically articulate? And then perhaps you prevail under that test, and perhaps you don't. But what's the test?
Well, minors is a very good start. I don't believe that we need identical ownership in title. If there is equitable overlapping ownership or something similar, that is sufficient, and that is what other states like New York have used, is their overlapping ownership. And these are not exhaustive factors. These are kind of guidelines for a court, but every test should be fact sensitive. I think the minors factor, where there must be an involuntary creditor, like a tort victim like Ms. Fell, speaks to the injustice. However, other states like Texas, South Carolina have said that injustice means to form a company to circumvent statute, avoid existing obligations, or sanction a fraud. That is not the type of conduct that the corporation should shield.
Thank you, Mr. Goldberg. Mr. Burke. Oh, I'm sorry.
Can I just ask one more question?
Oh, sure.
I apologize.
No problem.
Throughout your brief and some of the briefs of the amicus who have come to us, there's a strain that directs us to the regulatory scheme that it sort of underlies the case that you have here. You know, you have the Liquor Control Board, you have the liquor laws in Pennsylvania that are really, in part at least, geared to assuring that there is a financially viable owner of a liquor license. And I'm sure that this is true in other regulatory schemes in Pennsylvania. If we look at this test that you're advocating as applicable in situations where there is a regulatory scheme that's being circumvented by the use of the devices here, does that make sense in the context of the attempt to protect the public that you're arguing?
Yes, absolutely.
Okay, thank you.
Thank you, Mr. Goldberg. Mr. Burke.
Thank you and good morning. May it please the court, Robert Burke on behalf of appellees. Appellant offers no analysis and no reasoning as to why this court should adopt the single entity theory, other than doing so would permit the appellant to recover the remainder of her judgment from McCool Properties, an entity that was in no way responsible for appellant's injuries. There were many defendants who were found responsible, including the drunk driver and the employees of the famous restaurant who served the driver. And yes, 340 Associates, the entity that owned the liquor license and licensed it to the famous restaurant in accordance with Pennsylvania law and the approval of the LCB, was found to be 10% liable as well. Chris and Andy McCool are the only two members of 340 Associates. They were not responsible for appellant's injuries and could not and were not found to be so, nor was McCool Properties the landlord. There was no reason for the court to change existing Pennsylvania law that has been applied and relied upon for decades. But if the court is considering adopting the single entity theory, this is not the case to do it. The trial court applied both the Lumax factors and the single entity theory and correctly determined veil piercing was not warranted. The trial court's findings were supported by competent evidence and were upheld by the Superior Court. Given the narrow question upon which this Supreme Court granted aliquotter here, there is no basis to challenge those findings. In spite of this, it is the challenging of the trial court's findings and outright misstatements of the record that form the basis of appellant's appeal. I respectfully urge this court to reject those efforts. 340 Associates and McCool Properties operated as separate and distinct entities set up for separate and legal purposes. Under any theory, be it the single entity theory or the traditional Lumax factors, there is no basis to impose the judgment upon McCool Properties or the individual members of 340 Associates, Chris and Andy McCool. I would like to take a moment, if I may, to address some of the questions that were asked specifically with respect to identity of ownership, because I think that's an important factor here. There must be identity of ownership. It must be the same owners of both entities. And in this instance, we do not have that. And the purpose of that is quite frankly, due process. And the courts that apply the single entity theory discuss this. And many times they will say, because there's no identical ownership, you can't impose the liability on an owner of a company, in this case, the estate of Ray McCool, when he was not an owner of 340 Associates, the entity that has the judgment. And because of that, you must have identity of ownership.
Justice Baer, I think you've made your opening statement. You're beginning to go forward. So may I ask you? Actually, I have two questions. But on that point, what your worthy opponent's argument is to avoid fraud, to do equity. If we're going to hold to the identicality of ownership, then isn't that licensed to, and I'm not suggesting your client did this, although I would suggest that the record reads as if the trial judge is the McCool brother. I thought that the plaintiff never got a break in any of these things, notwithstanding everything, including a fraudulent transfer of the liquor license. Putting that aside, because that's the trial judge who I do not know, and I'm sure I have great respect for. Putting that aside, aren't we, if we adopt what you're asking, Justice Swift probe, setting this up so it's an easy matter to get mom or sister or wife to come in as a straw owner and therefore defeat the test we're trying to adopt?
I'm sorry.
Two corporations owned by Andy and Chris. After we write an opinion and we adopt your position, Andy and Chris get their mom, their sister, a wife, a buddy to be a co-owner of one of the corporations and not the other. The test is gone. But that's facts of law, not of equity.
I'm sorry, Your Honor. I'm having a hard time hearing your question. I apologize.
Okay, let me try one more time, succinctly. If you have to have uniform
we're having trouble hearing Justice Bear too. So,
Can I ask a question?
yeah, sure. Justice Mundy.
Well, the Justice Bear, like back. Can you, with regard to the identity of the ownerships of 340 Associates, could you explain the inference that Ray was a part of that association, and then some financial records were changed in 2013 to remove him as a part of that entity?
Certainly, Your Honor, and I'm happy to clarify that. Ray McCool was never a member of 340 Associates. The manner in which you determine who the members are is through the operating agreement. The operating agreement is a document that was initially in 2001, the three members were Andrew McCool, Chris McCool, and Charles O'Neill. In accordance with the operating agreement gets submitted to the LCB, and the LCB recognizes who the members are. The LCB performs the investigation into those members to make sure that there's no ties to organized crime or anything like that. And the membership of 340 Associates changed in 2004 when Charles O'Neill dropped out and the members were only Chris and Annie McCool. All the documents regarding the filings, the corporate operation, all the dealings with the LCP reflected 340 Associates members were Chris and Annie McCool.
Well, talk to me, excuse me, what I'm really interested in knowing is, tell me about the financial records that were amended in 2013.
The only thing that was amended and the only error that was noticed was that the tax returns indicated that Ray McCool was a member of 340 Associates. The tax returns that were filed with the federal government stated that Ray McCool was a 1/3 member. This was incorrect. And those tax returns were amended to correctly reflect that the members of 340 Associates were only Chris and Annie McCool. It's important to note, as the trial court found, that the tax returns are not evidence of ownership. The evidence of ownership are the corporate documents, such as the certificate of organization that was initially filed, that was initially prepared in 2001, and then was changed in 2004 to reflect that Chris and Andy McCool are now the sole members of 340 Associates. Every document dealing with the state, which is the Commonwealth, is the entity that determines who owns what. It's not the federal government. It's not the Department of Revenue. They do not determine who the members are of an organization. The tax returns were wrong and they were amended.
Thank you.
Counsel, it's Justice Donahue. If there's an example of a combine of companies, one of which requires the other, this would be it. And so I'm just trying, you mentioned in your answer to Justice Mundy that in order to hold the liquor license, the Liquor Control Board does an investigation of the owners to make sure that they don't have organized crime connections, and I'm sure their financial viability and things of that nature. The owners of this, of the liquor license here, who were issued the license, have zero beneficial interest in the use of that license. All of the proceeds that were generated from the sale of liquor inure to the benefit of McCool Properties, not to 340 Associates. And one could not really exist without the other. There, McCool Properties wouldn't be renting a bar space unless that bar had access to the liquor license, and vice versa. And so I'm trying to, am I understanding correctly that 340 Associates generated no income, nor did they incur any losses in the quote unquote operation of the business entity?
340 Associates certainly, Your Honor, incurred no losses in the operation of its business. 340 Associates absolutely did have income brought into the company every single month. 340 Associates was paid the benefit of the operation of the bar.
Okay.
Where did the money go? Okay. The money went to three places. The money went to, number one, it went to 340 Associates in the form of the fee that under the management agreement, the famous restaurant had to pay 340 Associates every single month the amount of sales tax that then 340, so that was income that was coming into 340 Associates. And then that,
let me stop you there. They paid them the sales tax?
yes. So under
any profits that were generated or any income that was generated from the sale of the liquor, all they paid was the sales tax on the liquor?
They paid the sales tax. Actually, technically, Your Honor, under the law, 340 Associates, as the owner of the liquor license, has to pay the sales tax on the sale of food from the establishment, because the sales tax for the sale of liquor is paid by the famous restaurant. So the income was coming into 340 Associates. 340 Associates was not earning what some would call a profit.
Let me just stop you there. If they're only being paid the sales tax that they then have to turn around and pay out to the state, that's a wash. I mean, that's nothing. 340 Associates doesn't gain, it doesn't lose.
It's not making a profit in terms of an additional fee from the, it's not making a profit per se from a fee from the famous restaurant. All the obligations of 340 Associates, every month it would get a bill from the state for the sales tax. Every month it would pay that bill. All the while, so it's not earning a profit, correct? Not earning a profit. All the while, it's holding a liquor license that is appreciating in value. It's in terms of capitalization, in terms of solvency, it's not necessary for a company to earn a profit. A company can lose money and still have sufficient capital. If you look at the Millers versus Brass Rail Tavern case, it's a very clear example. You had a bar, the court recognized the capital requirements of owning a bar are not substantial. In that case, the company was not earning a profit, but the court still found that it had sufficient capital to meet its needs, which is what the test is under the any Pearson corporate veil. I do want to.
Counsel, 340 Associates had no financial needs. They weren't operating a bar.
The only financial obligation 340 Associates had was to make sure that the sales tax on the food was paid every single month. And every single month, the sales tax on the food was paid by 340 Associates.
And where did the profits from the operation of the bar go?
The profit from the operation of the bar, absolutely, Your Honor. The revenue from the operation of the bar went to three places. 340 Associates, number one, in terms of the sales tax. That revenue went to 340 Associates, and 340 Associates paid the bill. The profit from the bar, the famous restaurant made a profit from the bar in terms of the money they were making from operating the bar, and also the money from the operation of the bar in terms of the rental went to McCool Properties. So if you look at the economic, who was receiving the economic benefit of the operation of the famous restaurant. In 2007, McCool Properties received $30,000 in rent from the famous restaurant. The famous restaurant received the profit that it was making off the operation of the bar. It paid its employees. It paid whatever else. It paid for the electricity, paid for food, paid for the alcohol. That's where the money was going from the operation of the bar. The notion that McCool Properties was receiving the sole economic benefit from the operation of the famous restaurant is simply false. And the trial court made those findings very, very clearly. McCool Properties did receive $30,000 in rent. It was market rent, according to the trial court. The trial court rejected the plaintiff's expert, accepted the defendant's expert. There was no improper benefit that McCool Properties was receiving from the operation of the premises because it was receiving merely because it was receiving $30,000 a year in rent for the operation of the famous restaurant. McCool Properties.
Can I just stop you there for 1 minute
Please.
then the only, did McCool Properties then pay dividends or something of that nature to its owners, who happen to be the owners of 340 Associates also?
It paid from time to time. It would issue a management fee or distribution to the members of McCool Properties, who were not the same as the members of 340 Associates. It would make payments to, I mean, keep in mind, please, also, McCool Properties owned 9 total properties in 2007, only one of which was the one where this bar was located. Where the bar was located was also 5 floors of apartments on the premises, and they also owned 8 other properties in other parts of the state. McCool Properties, in accordance with what it was allowed to do, certainly made payments to its members in terms of distribution, in terms of profit, in terms of management fees. Absolutely, it made those payments to those members, but it made those payments, all of it, which was done through McCool Properties and through McCool Properties operating agreement.
Just one more follow-up question. So 340 Associates and its members, the only financial benefit that inured to them from the ownership of the liquor license was whatever portion of the rent was paid to them, which was $30,000 a year.
Plus the appreciation of the liquor license itself. In 2001, the liquor license was valued at $140,000. In 2007, $5,000. In 2014, when the plaintiff was able to sell the liquor license, it was sold for $415,000. So you have 340 Associates, which is a company that never missed a payment on any bill, was always capitalized for its needs, held an asset that almost tripled in value, and had 0 debt. It was a company that was adequately capitalized, was certainly solvent, and meets no indicia of any Pearson and Corporate Veil standard.
Thank you.
Thank you, Mr. Burke. You've presented your case well. So, Justice Bear is back. We had some technical difficulties. Did you have a question you wanted to ask before we conclude?
Chief, no, that was my fault. I hit the power button trying to move the computer, in all candor. I always take ownership. Can you hear me any better?
No problem, but if you have a question, since you're back in business.
Well, yeah, let me ask only one, and it's just a follow-up of what I heard from Justice Donoghue. Famous Restaurant was in business to make money. It's an American enterprise. Where did its profit go? It paid its rent, it paid its employees, it bought its inventory, but it wasn't a not-for-profit entity. Where'd the profit go?
The profit went to the owners of, well, first off, there's no record on this, number one. But secondly, the profit went to the owners, Mr. and Mrs. Tapia. They ran the restaurant. They did it for a profit. They paid their employees. They paid themselves. They ran this business for 5 years, Your Honor. They did it to make money in accordance with their operating agreement, and they received certainly the substantial lion's share of the benefit of the operation of the famous restaurant.
Thank you very much, and Chief, thank you very much for allowing me to come out and fall back in.
It's good to have you back.
Thank you.
Okay, thanks both of you. We'll take a 5-minute recess and go to the next case.
The next matter is Commonwealth of Pennsylvania versus Thomas August Raboin. Representing Mr. Raboin is Mr. Robert E. Milnicki. Representing the Commonwealth is Mr. Francesco L. Nepa.
Good morning. In this case, appellant was convicted of involuntary deviant sexual intercourse with a child. During the rebuttal phase of the jury trial, the trial requested the child victim videotape forensic interview be admitted into evidence and played for the jury. For appellant's objection, the trial court granted the request, ruling that the interview was admissible as a prior consistent statement. The Superior Court ultimately rejected the notion that the interview was a prior consistent statement, nevertheless affirmed. I meant to say consistent. But the Superior Court affirmed, reasoning that the interview was admissible under the evidentiary rule of completeness embodied in Rule 106. The issue is whether the forensic interview was admissible under the rule of completeness. You may proceed.
Good morning, Chief Justice, Justices of this honorable court. My name is Robert Milnicki, and I thank you for giving me this opportunity to address this issue. Thank you. Before I begin, I want to point out that the rule of completeness is seldom seen in criminal proceedings. I've been doing criminal defense since 1991 as a public defender. I think I've seen it twice. As a civil practitioner, it's seen so often that we don't even ask why they're introducing the whole deposition. We just take it for granted that they're going to do it. In civil, the classic way is somebody points to a depo with a depo in hand, says, "Didn't you say this?" The other side doesn't like that taken out of context. They're going to get the whole depo in if they want it. Nobody's even objecting to that. In criminal, we don't see it. But if bond is going to remain good law, and I submit it should, then I think, given the prevalence of the prosecutors wanting to play that forensic examination, the Commonwealth is going to have to look for other ways to get it in. And right now, screaming at them from bond is wait until that defense attorney asks some questions and then go ahead. So I think this issue will become more important as it goes forward. Even if I'm wrong, the rule of completeness sits there without many appellate court decisions other than Bond, Baumhammer's, and other cases addressing what is its scope and when is it used. My amicus did a good job of bringing to the attention of this honorable court how it has been handled by some of the sister states, did a better job of that than me. It's going to be somewhat of an important issue because its scope is yet to be determined by this honorable court. Before I jump into the issues, I want to point out that last night I read in preparation of this the Commonwealth's brief for the second time. I read their amicus's brief for the first time, and I couldn't help but think that it's important for this court to understand my defense before I get to the issues and what sex offender court is, because the District Attorneys Association makes the representation out of thin air that as I was cross-examining the minor in this case, I had transcript in hand. Such could not be further from the truth and is inconsistent with the reality of Allegheny County Sex Offender Court. It is an admirable court. It is a court. I'm not here to cast aspersions at the court. I'm simply here to say and tell this court the reality. There are two key pieces of evidence for a person representing somebody charged with an assault on a minor: the CYF records and the forensic examination, particularly in Allegheny County. The CYF records are sent to the judge. We sit in chambers at a desk. We don't get copies of those. We take notes a month, sometimes months before trial. So when we go to prepare, we have our notes. We don't have those documents, which puts us at somewhat of a disadvantage in relying on our memory and our note-taking in forming questions. The forensic examination, we sit in the DA's office. We don't get a transcript early on. We don't get to take a copy of that CD with us. We rely again on our notes. And in this particular case, I also had the detective's notes that were there. Any suggestion that as I'm cross-examining that child, I have transcript in hand is wrong. It's blatantly false, and I don't know why they said it. They also do a lot, the Commonwealth joins their amicus in reading my mind, telling me, the only person here who was there, what I was doing and what I was trying to do in my cross-examination. The amicus even suggests that Judge Rangos at some point telling me, aren't you trying to do this? Me telling her no was somehow proof that what she said I was doing was what I was doing. That didn't happen. I did not have transcript in hand as I cross-examined the child, and that is distinguishable between the attorney in bond. In the attorney in bond, which brought this rule of completeness issue to where it is now, the way I read the record, he or she had transcript in hand. That was a classic cross-examination with transcript in hand where he went question and answer with the minor victim. And the state of the record in that case is he almost read the entire transcript. I never did that. I didn't have the transcript. I didn't introduce the transcript. I didn't do any of that. And that is important for the first issue. Did I introduce a statement or document as contemplated by Rule 106? My answer is I submit that I did not, as that term is contemplated by Rule 106. The comments, go ahead, Your Honor.
Counsel, it's Justice Baer. Would you agree with the characterization? Can you hear me?
I can, Your Honor.
Would you agree with the characterization that your cross-examination technique was to ask repetitively? And there's nothing wrong with this at all. Do you recall saying XYZ, which referenced back to this statement, this deposition?
There is no doubt, Your Honor, that I asked questions about what you said at the forensic examination, and I addressed 3 areas of the child's statement at the forensic examination, 3 areas that she testified to on direct. 1, what age was she at when she was saying that Raboin did this? I knew going in from Conifari's notes, he said she was 8. I knew from the forensic, she said she was in 2nd grade. She has a summer birthday. She would have been 8. I knew whether this part of the defense was going to carry today that I could get in evidence my client, and she said 1st and 2nd grade, so she's saying 7 and 8. I get it. But I knew for a portion of the time, she at least said at one time it happened, I could establish my client was not living in that small home. All I wanted, and I accepted the child's answer each and every time. She said, I said 1st and 2nd grade. Your Honor, I didn't challenge her. I didn't confront her. I accepted the answer because it was the answer I wanted. It's not, I didn't go after her. I accepted the answer and didn't challenge her. There was no misconception that the Commonwealth needed to clarify from that cross-examination. The other thing that I believe I asked her about, in addition to the age, was because I heard it for the first time. I knew going in, these cases are hard, Your Honor. I knew going in that she was saying it happened multiple times because she had to go to the bathroom and would always go in there, and seemingly Raboin was showering every time. Again.
Counsel, thank you. This is Justice Doherty. If I may ask you, let's talk about the legal issue that's before us. The issue presented is whether it was appropriate under 106 to introduce the forensic evaluation. Is it your position that because no document as defined in 106 was not introduced other than your questions, that it was inappropriate? I'm trying to cut this to the chase.
That's part of my argument, Your Honor. At the heart of my argument is it was improper to do a basic blanket admission, where my argument was essentially, I'll cut to the chase you want me to cut to. They got a near blanket admission. And keep in mind, Your Honor, the rule of completeness was not being discussed with the trial court. And I don't know if the most prejudicial parts of that, which I properly objected to, would have got into evidence and we would have been here had the rule of completeness been the basis to introduce at that time. And somebody had pointed out to Judge Rangos what the Superior Court said in Commonwealth versus Bryant. It is the burden of the person that wants to use Rule 106 to justify what misconception they're correcting. My primary argument, Your Honor, in addition to that, and I'll leave that on the briefs then, is that this was a blanket admission where, and not only was it a blanket admission, they got it in right before the jury went out. They didn't do it during direct. They didn't do it at the end of their case in chief. They didn't do it while I was cross-examining. They decided late in the game, in a rebuttal stage, right before the jury was going to go out to do it. And as part of that, even assuming, Your Honor, that they were entitled to play the portion where the child confirmed what I was asking, part of this occurred when she was in second grade, confirmed that to the extent anything implicit in my questioning was confirmed by playing the video. What they got in is my client was a horrible man, a horrible stepfather, didn't take care of children, for the first time pushed and shoved the mother, instilled fear in the children, which helped explain the prompt complaint, which the girl never testified to. My client worshiped Mother Nature and not God. Because the judge did a blanket admission and Rule 106 was never discussed, my primary argument is, I think the one that carries the most weight is, okay, so maybe you want to get into my cross and you want to correct what I asked, implicit in my tone, I guess, because I accepted the child's answers. I didn't go after her. Why the blanket admission? Why all the prejudicial things that had nothing to do with it? At one point, Judge Rangos.
Counsel, Justice Baer again. You're, and I'm sure it's unintentional. You actually asked these, do you recall questions twice? Once to the child and once to the detective. And I forget his name.
Conofari.
What is it?
Conofari.
Thank you. So a couple things apropos. First of all, this was only about a 39-minute tape, assuming a minute a page, which I think is the rule of thumb. So there's a limit to what you can cut out of a 39-minute tape. Second, you're dealing with questions to child and questions to detective that are all of the same ilk, and the Commonwealth trying to just make sure that the jury understood the record on what was credible or not credible. And then third, in terms of a question, isn't it, I was a little bothered by the timing too. It seemed to me the Commonwealth could have done this on redirect to the child, but then it occurred to me the Commonwealth may have not made this decision until rebuttal, because it didn't happen only with the child, but happened with the child and the detective, and it could have been the cumulative impact of all of your cross-examination that made them want to straighten out the record, in their view.
Conofari was still their case in chief, which was before my case, which was before the rebuttal. And let me address that. When they do it this way, I thought last night, she's saying my guy worships Mother Nature, she's saying this, she's saying that, the judge let it in. Suppose at that point I had said, well, I need to correct this. I need to address this because I never went through this with the girl on cross. These things she's bringing up about being a poor stepfather, being abusive, worshiping Mother Nature, all that other kind of stuff, she's bringing up on a videotape, not from the witness stand. Judge Rangos, I would like to call the minor to the stand again and serve rebuttal. I don't think she lets me do it. because I think at that point in time, her mindset is, what are you, sir, rebutting, sir? She's not going to let me do it. That's the unfairness of this, is they got in things that were unfairly prejudicial, irrelevant. And then Judge Rangos, during the in-chambers discussion, at one point says to me, and I say to her, Your Honor, with all due respect, the child never testified to that. This is about using this video to impeach my client or using this video to supplement what the child was done. And the unfairness of the timing is, what do? Ask for sir rebuttal to respond to a video? I don't think I get sir rebuttal.
Justice Todd. Oh, pardon me, Justice Bear.
No, it was me, but go ahead.
Oh. Counsel, Judge Rangos admits in her, or acknowledges in her 1925A opinion that it was an error to have allowed this whole video in, correct?
She says it was a harmless error, correct. I can address that, but you're correct.
But then she goes on to say that the information was not contained in the video was not overly prejudicial. It was in most respects cumulative, and it was harmless error. Also, that you had the opportunity to cross-examine the victim about most issues that were in the videotape. So I guess I'd like you to address cumulative evidence and harmless error and prejudice. I know that's a multifaceted.
I get it, Your Honor. I'm actually ready for that one, because in Bond, the Superior Court did a strange thing. After they rejected, and his cross was worse than mine. It was easy, or her, I don't know. In Bond, what the court said was, you're right about prior consistent statement, which was kind of news to me in Allegheny County, because we assumed that's why it was coming in. You're wrong about prior consistent statement, but it's harmless error because it was cumulative of the very questions that attorney asked. But again, he went line by line through a transcript. So he's just asking to reaffirm the answers he already got. And they point out about that attorney, you don't even come to us pointing out how you were prejudiced by this. You don't even argue that in your brief.
Mr. Manicki, I'm sorry to interrupt you, but when you said that you did not have the entire videotape or have the videotape, when you were in the DA's office, were you permitted to watch the entire video?
I watched that. I don't remember when in relation to the trial. I watched that. I took some notes, yes.
So you were permitted to see the entire video?
We see the entire video with a headphones on a laptop in a DA's office. We take notes. We don't get a transcript until late in the game, and we don't get a copy of that.
Understood. But you see the entire video and you can take notes on it? Yes, we can. Please proceed.
With respect to the Bond court, first they say it was cumulative and therefore not harmless.
Yes, just answer Justice Todd's question. I ask you three simple questions.
Okay. I disagree with her that it was not prejudicial. I put in the prejudicial things in my brief to this court. I raised them to the Superior Court. The stuff about him being abusive, not brought up during the trial, that's pretty prejudicial. The stuff about him not being the best stepfather, the part about him being
about cumulative and harmless error. We don't want to hear all this other stuff again, because we're going to move forward with the argument. Then Justice Donahue has a question. But if you'd like to respond to Justice Todd, go ahead. If you remember,
I don't agree that it was harmless error for the reason that all those prejudicial things came in at an inopportune time for them to come in right before the jury went to deliberate. I don't know if that answers your question. I don't agree.
Do you have any follow-up?
Well, I guess my question still is unanswered as to the cumulative nature and how it relates to harmless error, because here the big bang testimony is the sexual abuse, right? The sexual acts that occurred, according to the victim, in the bathroom of the family house. these additional points that came out in the video, which you had had an opportunity to see weeks or months before, pertain to her view, the victim's view that he was mean, or he pushed her mother, or some things like that. Not that they're inconsequential, but those are not the big bang subjects that pertain to the crime.
But if my client had a criminal record and they got in improperly his criminal record, Your Honor, that wouldn't go to the big bucks of the crime. That would still be prejudicial. I never cross-examined that.
I understand your position. Thank you.
All right.
Justice Donahue has a question.
Thank you, Chief. I just want to clarify what you're arguing, because as your argument progressed, you contradicted what you said in your opening. So I'm just trying to get some precision here. You are arguing for application of the rule of completeness, so that at the time you use a statement of, in this case, the victim, the Commonwealth at that juncture would have to identify what the misconception is that you have articulated, and at that point offer the counter statement of the victim. Is that correct?
My argument is Rule 106 says at the same time.
Because what, in your opening you said, well, I agree with Bond that the entire forensic interview should come in. That's just not the rule of completeness by any stretch of the imagination.
If I said that, I misspoke. I'm arguing that it's not a weapon, a blanket admission.
That's why I'm trying to clarify, because it's precisely what you said in your opening. So
okay,
let me ask you another question here regarding how this works when there is no transcript. I mean, if you did not use the videotape in order to impeach or otherwise cross-examine, why would the Commonwealth get to use video? Why would they not at the same time get to offer a statement from the video that clears the misconception? Because to me, part of the prejudice here is not only when it was played, which was, a significant deviation from the rule of completeness, but that the child essentially got to testify again. So
yes, sure.
If you don't use the video, why would the Commonwealth in this situation get to use the video as opposed to referring to another part of the forensic interview where the child said something different?
I submit that's what should be done. The problem in this case, Your Honor, is the rule of completeness was never brought up at trial.
Obviously.
And I wonder what would have happened if instead of prior consistent statement, Judge Rangos, who can be fair, is addressing the rule of completeness, and I'm saying, okay, Your Honor, but that's only portions of the video and they can do transcript. I'll agree to it. We never got there, Your Honor, because the rule of completeness was never brought up. In Allegheny County, they have been playing these forensic examinations in their entirety, for the most part, maybe not every proceeding, as prior consistent statements under Hunzer, and along comes Bond, and we backtrack. So I don't know if we would be here if we had argued rule of completeness at the trial court level. This is an after-fact reason for affirmance by the Superior Court that brings it up for the first time, which I submit alone is problematic when the burden to justify the rule of completeness was on those who wanted to utilize it, and it wasn't even being argued at the time of trial.
Thank you.
Thank you, Mr. Nepa.
Good morning, Your Honors. Francesco Nepa for the Commonwealth. The defense seems to want to have it both ways here. They want to suggest to the jury, they wanted to suggest to the jury that the victim was lying because of what she had said during the forensic interview, but they didn't want the jury to hear the forensic interview. And that's unfair. And it would seem to me that that's exactly the sort of unfairness that Rule 106 was created to combat. Just look at the rule itself. The rule says that if a party introduces a part of a recorded statement, the opposing party may introduce any other part of the statement that, in fairness, ought to be considered along with it. And the comment to the rule explains the purpose behind it is to give the opposing party the opportunity to correct the misleading impression that the other side created by using the recorded statement in a way that maybe would be taken out of context.
Mr. Napa, not to interrupt you coming out of the gate, but the trial judge, Judge Rango, is a very able judge, said it was error to admit this.
No, she said that she thought it was error to admit it as a prior consistent statement. The argument that I made, and she might be right about that, but the argument that I made to the Superior Court was, even if that were true, it would have been proper to admit it under Rule 106. And from the jury's perspective, they would handle it the same way. And the Superior Court agreed, and we believe that they were correct. Mr. Milnicki talks a lot in his brief and today about how he never tried to admit a transcript or play a portion of the recording for the jury or go line by line when he was cross-examining the witnesses, but it actually served his purpose better not to do those things. Because
here's the problem. As I understand his argument is still to its essence. There were things in that complete transcript that had never been raised on direct examination, cross-examination, and the jury heard those things.
Well, first of all, I wouldn't say that that's true. I don't think there's anything in there that the jury had not heard before. If there were these differences, let me get back to what I was trying to say about the going line by line thing. It helped him not to draw the witness's attention to the transcript, because doing so would have revealed that what he was implying wasn't accurate. And two, being less precise about what the victim said by not pointing to something in a transcript, that allowed the defense to just generally insinuate that there were things said during the interview that damaged the Commonwealth's case. And how can the defense be allowed to do that without the Commonwealth being allowed to let the jury hear exactly what went on?
Commonwealth, this is Justice Doherty. As counsel has indicated, there was reference to the defendant being, for no other purposes, a Wiccan. Is that not prejudicial? The fact that you're in front of a jury, you're saying that a person is quote unquote a witch?
I don't think that got in. That's another problem I have with Mr. Milnicki's argument. He says there was a blanket admission. That's not true. There was several pages that were removed from the video. The parties were in chambers prior to the playing of the video, and they went through it. And Judge Rangos removed certain things. And I believe that what you're referring to, I don't think that part stayed. I stand to be corrected, but I don't think so. I don't think that was.
Excuse me, Mr. Nepa, is that in the record for us to review the actual parts of the video that were played?
Yes. It's in the trial transcript just prior to the video being played.
Okay, thanks.
Counsel, it's Justice Donahue.
Yes.
Either we're applying Rule 106 or we aren't. I mean,
either you're what? Excuse me?
We are either applying Rule 106, the rule of completeness, or we are not. I mean, It's a very precise rule.
Yeah.
You have to identify what the misconception is, and then you're allowed to admit so much and no more than is necessary to correct the misconception.
Well,
yes. I mean, that may mean not necessarily during the cross-examination. It would certainly be on redirect that you would have to do it, but not in rebuttal. I mean, and I think that's the issue we have before us. I mean, how do you apply the rule of completeness in this situation?
Well, Mr. Milnicki, for the first time today, is making the argument that we didn't carry our burden in the trial court. I didn't think that was the issue that was framed, because we made the argument to the Superior Court that there was the record was sufficient enough to show that Rule 106 was applicable, and this court is able to affirm on any valid basis that's of record. So I don't know that the fact that we did not precisely identify what exactly should come in under Rule 106, I don't know that that dooms us here. I don't even know that that's the issue.
But then, counsel, that's not Rule 106. That's just something else. I don't know what it is, but it's something else. It's not the rule of completeness. I mean, that rule has that name for a reason.
I don't understand. I don't understand. I'm sorry.
If you're asking us to say that you don't have to identify the information that was given that created a misconception, then that's not Rule 106. If you're allowed to put more in than is necessary to correct the misconception, then that's not Rule 106.
We didn't do that. And what I said to the Superior Court and what I'm saying to you is, when the defense is suggesting that there's something contained in that interview that undermines the accusations that the victim made from the witness stand, we are allowed to play the entirety of it for the jury to show them that there was nothing in there that undermined what the victim said. The rule says we can play any other part of the statement. And in this instance, we had to convey to the jury that there was nothing in there that undermined the victim, contrary to what the defense was suggesting.
Mr. Nepa, it's Justice
Yes.
Todd again.
Yes.
Let's assume for just this part of the argument that, as Judge Rangos acknowledged, it was an error for her to have admitted the video under Rule 613. And let's also assume, for the sake of this argument, that it was an error to admit it under 106.
Okay.
Would you go on then and address the same question that I asked Mr. Milnicki, harmless error, prejudice, cumulative? Does all of this matter given what the primary evidence was and the additional evidence that came in during the video?
Our position is that everything that was in the forensic interview is cumulative of what the victim testified to at trial. The complaint from Mr. Milnicki in his brief is that this video allowed the jury to see him as a mean person or a bad man. All that stuff is in the victim's testimony from the stand. She said she was afraid to tell her first grade teacher she wanted to, but she was afraid because she thought that the defendant was going to hurt her. She said that he was a very tall man. She said he pushed her mother. She saw him push her mother on at least one occasion. That was all testified to from the stand. So if you look closely at that testimony and then you look at the transcript of the interview, we don't think there's anything in there that is new or prejudicial. The jury had heard all of it before.
Okay. Sharing her transcript of her testimony at trial with everything said in the video. Let's assume it wasn't 100% cumulative. Then please go on to address whether or not it was prejudicial and whether it was harmless error.
Well, it would be harmless because there's nothing in there significant enough. There's nothing different that is significant enough to overturn this jury verdict. Like I said, I think it's pretty much step for step with her trial testimony. If you find something in there slightly different, I don't know that it has any sort of significance. That's our position. Anyway, the record speaks for itself.
Can I follow up? This is Justice Baer. I want to follow up for 1 second on Justice Todd.
Sure.
Will you comment quickly about the timing? Your opposing counsel said by not doing this at the same time, and I don't think the rule has to be read literally, you had a tremendous unfair advantage because you played this uninterrupted videotape immediately prior to jury, as the last evidence before the jury retired to deliberate.
Yeah, I know that the rule at one point used to have the word contemporaneous in it, and it's been removed. You guys did that. There's a reason why it's no longer in there. I think now it says at the same time. I mean, that can't mean literally at the same time. So I would read it more. The two things are to be considered at the same time by the fact finder. The defense used the video for its purpose, and then the Commonwealth suggested, well, here's the whole thing, and the fact finder should look at the entirety of that video in making its decision.
Don't you think it's a more reasonable?
You guys, did you just
I apologize. I'm sorry.
That's all right.
Don't you think it's a more reasonable reading of that? It obviously can't be literal, but it could have come in redirect of the
It could have,
or
but
redirect of the detective.
It could have. I think you made the point earlier. I mean, maybe the Commonwealth didn't absorb, maybe the trial attorney didn't absorb until reflection that, hey, given everything that's come out through these two witnesses, hey, we need to be able to play this. And I don't think it was too late. In the Baumhammer's case, there were something was played in the guilt phase, and then something that had to be played in the penalty phase. And this court said that was too remote in time. Those are essentially two different proceedings. This was the same proceeding, so I don't think it was too far in time.
I think we worked this over pretty well, Mr. Neppa.
Thank you.
Any other questions, we'll conclude the argument.
Thanks.
Hearing none, we'll break for 5 minutes.
The next matter is the Commonwealth of Pennsylvania versus HD. Representing the Commonwealth is Ms. Jill M. Graziano. Representing HD is Mr. Patrick J. McMenamin Jr.
Good morning. In this matter, the defendant was convicted with interfering with the custody of her child. The defendant believed her child was being abused by the child's father. So, in violation of the custody agreement, she took the child to court for several weeks. The court is asked to determine whether her belief that the child was being abused should be measured by an objective, reasonable person standard. You begin your argument, please.
Thank you, Your Honor. Good morning, and may it please the court. Jill Graziano on behalf of the Commonwealth of Pennsylvania. Your Honors, it is undisputed in this matter that on June 18th of 2016, appellee, in violation and defiance of a lawful custody order, absconded with 5-year-old GB, left the county of Bucks and the state, ultimately the state of Pennsylvania. She evaded efforts by GB's father and law enforcement for 45 days as they searched for GB's whereabouts. And ultimately, upon her apprehension on August 2nd of 2016, she refused to disclose GB's location, requiring law enforcement to undergo additional investigation to locate her in Miami, Florida, and reunite her with her father. At trial, appellee asserted the defense set forth in 2904B1. She alleged that GB was being abused by her father. Commonwealth presented evidence at that trial to prove that appellee's belief was unfounded and unreasonable. And the question before Your Honors is, was it required that appellee's belief be a reasonable one in order for her to successfully avail herself of that defense?
Counsel, could I ask a question?
Of course, Your Honor.
If that was the law, why wouldn't we expect the General Assembly to put the word reasonably in front of the word believed? Is there some reason the General Assembly can't do that?
Well, there's no reason they couldn't do it, Your Honor, and obviously we wish they had. But the Commonwealth believes that there are two reasons that the plain language of this statute does not accurately and effectively represent the legislative intent of 2904. The first reason would be that the first reason would be that we would respectfully ask that you don't look at 2904B1 in isolation. It was adopted in 1972 at the same time that Title 18 was adopted and the Crimes Code was codified. As part of that codification, two additional provisions, two general chapters were adopted, specifically Chapter 5 relating to justification and Chapter 3 relating to general principles of culpability. And I would specifically and respectfully direct Your Honors to look at Section 501 and 503 of Chapter 5, in which belief is defined as reasonable belief, and justification is defined as when an actor takes a otherwise unlawful act because they reasonably believe that that otherwise unlawful conduct justifies or prevents a greater harm or evil. Also, in Chapter 3 relating to culpability, there is a provision, Section 304 of that chapter, which talks about ignorance or mistake of fact.
Commonwealth, this is Justice Doherty. If I may pick up where Justice Sweck left off with that question. The question of concern, I understand what you're sharing with us, but when I look at that jury instruction, the jury instruction is really a general justification instruction and not a jury instruction with regard to the actual statute of 2904. How do you get around the fact that the jury instruction provided is not related per se or not verbatim as to what the statute is? I'm having a problem with your implying or applying a general justification jury instruction to supersede the plain language of 2904, for which, as Justice Weck indicated, there is no reasonable language in there.
And Justice Doherty, I can't get around, I wish I could, I can't get around that reasonable is not in that statute. What I am asking the court to do is look to other principles of statutory interpretation, because the Commonwealth's assertion is that if you don't include a reasonable belief, if you don't require a reasonable belief under the statutory provision, not only does it ignore other general principles of culpability and when justification defense can be used, which I think can be inferred that the legislature understood that those other principles would inform the term belief as used in 2904B1.
To do that, you would have to find 2904 ambiguous.
And I believe it is, Your Honor. I believe it's ambiguous for two reasons. One is because, as we pointed out in the Commonwealth's brief, if we say that a subjective belief alone would justify and serve as a total defense to this particular crime, you are virtually singling out this one crime whereby a subjective and not a reasonable belief would be enough to serve as a total defense and virtually make one immune from criminal liability under this section.
But it was created by the General Assembly without that language. Who's to say that that was not the intent and purpose of the General Assembly?
Well, I would ask Your Honors to be the ones that determined that was actually not the intent of the General Assembly. Because again, I believe that you can look to other provisions of general culpability and justification defense and how it is applied in other criminal contexts.
Ms. Graziano?
Yes.
Is this statute track the model penal code?
I'm sorry, could you repeat that, Your Honor?
Does this statute track the model penal code?
Yes, it does.
Is the commentary for instructive the commentary to the model penal code?
It's instructive only in the sense that I believe it defined what the objective of the statute was. It does not specifically, as far as I could read, get into how the defense was to be interpreted.
But it says this, it kind of explains why reasonable was deliberately omitted. And here's the quote: it might be plausible to exculpate liability only for those who can show a reasonable belief in the necessity of their actions. But it may be extravagant to demand reasonableness from a participant in a custody dispute over his own child. Section 1A therefore requires only an honest belief that the conduct was necessary to preserve the child from danger to its welfare. That's comment 3 to the model penal code.
And Your Honor, I would submit that when there was the joint commission and they recommended to the General Assembly to adopt and codify common law in Title 18, I don't know if that specific comment was actually put into the Joint State Commission's report. I certainly didn't see that in that report. And there's nothing beyond the model penal code comment to indicate that was the intent. But I think what that provision points out.
It would be instructive and it would answer actually before the court, or the court believed that there was that comment in terms of the statute law of Pennsylvania.
It's certainly instructive, Your Honor, and I'm not asking you to ignore it. But what I am asking this court to do is consider even the limitations of that commentary, which is it talks about the extravagance of inserting oneself into a custody dispute when emotions are high and emotions may not be formed by reason. But this act does not speak only to parental kidnappings. And if you think about how 2904B1 could play out in other circumstances, it shows just how untenable the results can be. And I would submit, for example, Your Honors, that if GB had not been abducted by her mother, for example, but had in fact been abducted by a neighbor or a family friend or a babysitter who sincerely but unreasonably believed that GB was in harm's way while in the custody of her parents, and they abducted GB and removed her from parental custody and from the state of Pennsylvania for a period of 45 days, as was done here, that person would also get the benefit of 2904B1 and go without criminal responsibility for those acts, so long as a jury believed that that actor's belief was a reasonable, was a sincerely held belief.
Counsel.
Yeah. I'm sorry.
No, go ahead. Go ahead, Justice White, please.
Just to follow up, why isn't that an argument that quintessentially, that sounds like a great argument you could make to the General Assembly. You have an association, they briefed as an amici in the last case we just heard. And what, in the meantime, instead of trying the case under the statute you want, why doesn't your office try the case under the statute you have? Specifically, instead of cross-examining the actor on whether her belief was reasonable, why didn't your office vigorously cross-examine to show the belief was a sham, or to show that the belief asserted was disingenuous? See, because at your peril, your office presses on with reading of the statute that's contrary to what the General Assembly has on the books.
Your Honor, Justice White, I don't believe that I believe we took the tack we did, and I admittedly was not the trial attorney in this case, but I believe we took the tack we did because I'm not sure that there is evidence to show that her belief was not sincere. It was just unreasonable. It had been debunked after numerous investigations. And the problem the Commonwealth has is if we deal with the statute and assume that the belief is subjective only, not objective, then this conduct will go unpunished again, unless and until we have the General Assembly insert the word reasonable.
Well, there's a lot of injustice. There's a lot of injustice in our world. I don't know what the principal stopping point in your argument is. If you can come to us and say, justices, this is an injustice crying out for you to fix. Please fix this. If we fix your injustice in derogation of what the General Assembly legislated, I don't see any stopping point. We're going to have a crusade that will consume at all times.
Well, Justice, I respectfully disagree with that for the following reason. There are other principles of statutory interpretation that exist beyond merely looking at the plain language. And I understand that the plain language is the typical default. But there are other statutory provisions at play. And one of them is that when you examine, that the court may examine practical effects of a particular interpretation and must presume that the legislature did not intend absurd or unreasonable results. And I believe here that allowing a subjective intent or subjective belief alone to dictate whether a person is criminally responsible for a kidnapping of a child, a parental kidnapping, or frankly, as I used in my hypothetical earlier, it doesn't even need to be a parental kidnapping. It could be an actual abduction of a child based on a sincerely held belief.
Counsel.
Yes, Justice.
Justice Baer. I want to follow up on that point very precisely. So that's why I interrupted what I thought you had already answered, and we're moving on. The reason for this statute is that mom has a lawful authority to this child, be it by virtue of being the natural mom or perhaps by court order. If it's the babysitter or the next door neighbor, it's garden variety kidnapping. And you don't pull out this statute. You charge them with I assume it's a felony of kidnapping, serious crime, and you prosecute them. So this statute has a very, very narrow thrust, inapplicable to your parade of horribles. Isn't that correct?
I would actually disagree with that, Justice Baer, for the following reason. Kidnapping has elements that are not present when somebody is sincerely believes that they are saving a child from a further abuse or harm. There are specific intents that a kidnapper under the kidnapping provision has to possess in order for us to prove that kidnapping. So you can't take somebody who, if a babysitter, for example, had abducted GB and removed her just to protect her ostensibly. That does not meet the elements of the kidnapping. So
that would-
garden variety.
We won't get into that digression. That would surprise me greatly. It would surprise me greatly that any defendant can mount the defense that in a kidnapping of a stranger, and when I say stranger, legal stranger, I'm not suggesting they don't know each other, that I did it for their own good. But be that as it may, I only had one other point, which was apropos of Chief Justice citing to you the model penal code. Pennsylvania clearly intended to follow that. In the standard jury charge instructions, there is a commentary on interfering with custody of a child, and the commentary says we rejected the word reasonably. We followed the model penal code. So apropos of Justice Weck, you don't like the law, but that's the law.
Well, Your Honor, we don't like the law because we don't believe it's just, but we actually do believe that this court has the power to correct it under principles of statutory interpretation that currently exist.
We understand. You think we could,
we got it.
Purely and without doing violence to anything, read the word into the statute as we occasionally do to other legislative enactments. So you can be assured we have. And if you have a word or two by way of information, because I think your microphone's got some feedback problems here.
Oh, I apologize, Your Honor.
That's not your word. Anyhow, do you want to sum up and we'll hear from the Aplt?
Your Honor, but I will just briefly make mention of one case. This is not the first time that we are asking a Pennsylvania appellate court to make a practical common sense reading of 2904B1. And I would point you again to, as we did in our brief, to Commonwealth v. Couch, a 1990 case from the Superior Court, in which that court said that the word danger in 2904B1 has to be an instant or immediate danger. That word was not in there. And yet the court read that as a practical common sense application of what that statutory defense must mean. We are asking this court to do the same here in order to uphold what we believe is the true intent of the legislature. Thank you.
Thank you. We'll hear from the Aplt.
Thank you, Mr. Chief Justice. May it please the court. Associate Justices, my name is Patrick McMenamin, representing the appellee, who was the defendant in this case at the Court of Common Pleas, and is the mother of the child who was subject to the underlying custody order. It's our position that the language in the statute is clear, precise, and it's not ambiguous. As a result, the intent of the legislature is also clear. If a parent honestly believes that her child's in danger, she does not commit a crime by violating the other parent's custody rights. The defense focuses upon what the parent genuinely believes, not what the jury thinks is reasonable. This makes sense when we consider that the statute deals with a unique situation in which a parent is required to decide whether to abide by a custody order or not for the safety and protection of her children. Such a decision should not be subject to hindsight critiques using a reasonableness standard by the jury. The Superior Court decided the case correctly when it found that the trial court erroneously instructed the jury with respect to statutory defense. The Superior Court accurately found that when reading the statute as written, the term reasonable was not included.
Mr. McMahon, could you just, sorry to interrupt you. Justice Baer, could you mute your mic?
Oh, I'm sorry, I didn't know it was unmuted. Thank you.
All right, that's all right.
In fact, in touching on something that Ms. Graziano said, when we look at other sections of the Crimes Code enacted at the same time as this statute, we find that the legislature has created statutory defenses using the reasonableness standard. We find this in criminal trespass defense. We find this in the unauthorized use of motor vehicles defense. The statute is written so that the jurors are required to assess whether the defendant really believed the child was in danger or whether the claim of danger was just an excuse to remove the child from the other parent's custody. By using the term reasonable, we shift the review from what the defendant actually believed to whether the jurors believed that the defendant's actions were reasonable under the circumstances. We allow the jury to decide the parent's state of mind using a reasonableness standard. We potentially implicate a parent who honestly thought she was protecting her child from danger, even if that belief may have been objectively unreasonable. In many instances, yes.
It's Justice Donahue. You keep referring to the parent's decision and the parent's right and the parent's judgment. This statute doesn't only apply to parents. And I agree with your argument. The statute says what it says, but does it make sense? Is it an absurd result if it's the nanny who decides that the child's welfare is in danger? I mean, the Model Penal Code makes specific reference to the fact that they don't want the criminal law to interfere with custody disputes. But if it's not the parent and it's a nanny or it's a next door neighbor, does your interpretation of reasonable not being part of this analysis create an absurd result?
No, I don't think it does, because for example, if we're talking about the nanny, that person would presumably have a duty of care towards a child. So if that person with a duty of care clearly believes that the child is in danger, that person should act. And in fact, if a nanny, and in this case there was a nanny, if the nanny actually believed that the child was in danger and failed to act, you could make the argument as a prosecutor that the nanny was committing the offense of endangering the welfare of a child. So I think,
Mr. McMahon, that's just, I think that's going far afield here. A nanny might have a duty to report to the police what she believes is happening or the danger she sees to the child, but she wouldn't have a license to take the child and go to Florida. I mean,
well, I would agree with that, but again, I don't believe that it creates a ludicrous or ridiculous outcome when we apply it to somebody other than a parent. In this case, clearly we're dealing with a parent, but I think that if there is a legitimate belief on somebody who has a relationship with the child, regardless of whether it's a grandparent or a nanny or a neighbor, that the child is in imminent danger, I think that that person would also have protection under this defense.
I have a question. Regarding genuine feeling of that you described, that the mother or whoever's charged had a genuine concern, a genuine feeling that the child was in danger, as opposed to the reasonable belief that could be determined, as you indicated, by a jury. What if the genuine, sincerely held belief is outrageous? What if it's that the mother believes the father is an alien from outer space and is going to remove the child from the planet? How would you handle that? Same way?
She nevertheless has a defense if she genuinely believes it. That's how the statute reads. Again, the legislature could have put in that we are to judge it on whether it's reasonable and whether the mother or the person had a reasonable belief that the person creating the danger was from outer space. But that's not what the statute says. And I would agree that if we're looking at it from a reasonableness standard, the argument has to make sense. It has to be logical. It can't be that it's an alien or that the parent belongs to a cult. But
under your theory, it can be.
Under my theory, that if the defendant has a legitimate belief, and that's what they really believe.
Wait. You're saying legitimate now. We were saying before genuine or sincere, as opposed to objectively reasonable. Let's not add any other adjectives.
If the defendant believes the child is in danger, the defendant has a defense. That's my position.
Thank you.
Counsel Justice Baer, I'm curious, you therefore agree with the Commonwealth that if the next door neighbor or the school teacher or whatever takes the child, absconds with the child, and goes to Florida, that the district attorney can't bring kidnapping charges under a typical common law kidnapping scenario?
No, I believe that the Commonwealth can bring kidnapping charges. The question becomes at trial, does that person under this particular section, not kidnapping?
They don't charge under this section.
Right, they charge under kidnapping.
Right. Is this a defense to kidnapping?
Not a defense to kidnapping.
All right. So this defense, so that the school teacher takes the child and runs with the child, they charge under, I'm going to call it common law, but you know what I mean, statutory typical kidnapping, and I don't know the section off the top of my head. Is there any room in that case for the defense that they were acting in good faith and believing the child was at risk and they were saving the child?
It's not a statutory defense to kidnapping.
All right. Let me ask you, this child now is 9 or 10?
Yes.
What's the custody arrangement?
Mother has no contact with the child, although it's not part of the record. She has.
Well, it's part of a record. We can take judicial notice. Go ahead.
She has made attempts after the Superior Court overturned her conviction. She did make attempts to go back to Bucks County Custody Court and to at least reestablish contact with the child. And thus far, the Bucks County Family Court has declined to put her in any type of contact with this.
So the Commonwealth's argument that mom has not been, quote, punished, end of quote, is illusory. She is suffering a far worse punishment than anything she could imagine. She sincerely held this belief sufficiently to uproot her life, child's life, run and hide. And the aftermath is she has no relationship with what is most precious to her, and indeed all of us.
And putting my family court hat on for a moment, not only is this woman suffering this as a penalty, but in my opinion, the child is likewise being further victimized by having no relationship whatsoever with her mother.
Thank you.
Thank you. Thanks to both counsels, and we'll adjourn till 12:30.